Teachings on relationship and separation. Domestic relationships, civil or life partnership and separation. A domestic partnership is a legal or interpersonal relationship between two individuals who live together and share a common domestic life but are neither joined by marriage nor a civil union. A domestic partnership is almost equivalent to marriage. Domestic partnerships may involve either different sex or same-sex couples. One of the purposes of domestic partnership relations is to recognize the contribution of one partner to the property of the other. Cohabitation, also referred to as a common law marriage, living together, or a domestic partnership, is not recognized as a legal relationship by South African law. There is, therefore, no law that regulates the rights of parties in a cohabitation relationship. This relationship, where a man and women or man and man or women and women living together do not have the rights and duties married couples have. This is the case irrespective of the duration of the relationship. A cohabitant can also not rely on the provisions of the Maintenance of Surviving Spouses Act to secure maintenance on the death of a partner. Furthermore, there is no obligation on cohabitants to support each other, and they have no enforceable right to claim maintenance. The current legal position about life or domestic partnerships in South Africa is fraught with inconsistencies. To begin with, there is no law of domestic partnerships, so none of the invariable consequences that attach to marriage attaches to non-formalized domestic partnerships, and such couples only have the ordinary rules and remedies of the law, such as the law of contract, estoppel, and unjustified enrichment, at their disposal. This general position has been developed on an ad hoc basis by the legislature and the courts so that domestic partnerships receive recognition under certain circumstances. As far as the judicial developments are concerned, this recognition has been limited to same-sex life partners, as, at the time of the applications for an extension being brought, same-sex marriage was not yet legally permissible, with the result that a domestic partnership was the only form of conjugal relationship open to gays and lesbians in harmony with their sexual orientation. The Constitutional Court was in Volks No v Robinson and others 2005 5 BCLR 446 cc of the view that the law may distinguish between married people and unmarried people and may, in appropriate circumstances, accord benefits to married people which it does not accord to unmarried people. The learned justice reasoned as follows in the paragraph. There is a wide range of legal privileges and obligations that are triggered by the contract of marriage. In a marriage, the spouse's rights are largely fixed by law and not by agreement, unlike in the case of parties who cohabit without being married. Four elements seem to be essential for the creation of a cohabitating relationship, namely: a sexual relationship between the couple, a factual cohabitating relationship, and the measure of durability and stability of the relationship. And consortium is the loyalty, care, affection, and concern for the material needs of physical care and the rendering of services in the running of the common household. Salient features of the draft Domestic Partnerships Bill. In January 2008, the South African legislature unveiled its first concrete attempt to regulate the position of life partnerships in South Africa in the form of a draft domestic partnerships bill. This draft bill provides for two forms of domestic partnership, registered and unregistered. Entering a registered domestic partnership involves a public commitment in the form of a formal registration process that is undertaken by two persons, irrespective of their gender, neither of whom is married or in a civil union or another registered domestic partnership with an outsider. Because of registration, many of the legal consequences that attach to a valid marriage are extended to the partners. For instance, registered domestic partners will be placed under an ex lege duty to support one another according to their respective means and needs, will be prohibited from disposing of joint property without written consent, and will be entitled to occupy the family home irrespective of which partner owns or rents it. A registered domestic partner will also automatically qualify as a spouse for the Intestate Succession Act 14 and the Maintenance of Surviving Spouses Act 15(7) 2006 1 Sa 524, cc. Hereafter Minister of Home Affairs v. Fourie as the preamble to the draft bill, which refers only to opposite-sex couples and therefore should be amended. The Civil Union Act defines a civil union as the voluntary union of two persons who are both 18 years of age or older, which is solemnized and registered by way of either a marriage or a civil partnership, following the procedures prescribed in this Act, to the exclusion, while it lasts, of all others. In the youngest case law in McDonald v. Young, 29 2/10, 2011, SCA 31, the court found that whilst there was a reciprocal duty of support between married persons, no duty of support arises by operation of law in the case of unmarried cohabitants. This was an unequivocal statement of the law by the Constitutional Court. Squire, Judge, went on to state that to the extent that any obligations arise between cohabitants during the subsistence of their relationship, these arise by agreement and only to the extent of that agreement. There is some legislation that places cohabitation and marriage on equal grounds. The cohabitation of same-sex or life partners is recognized under the Domestic Violence Act. The law does not distinguish between married and unmarried parents about the obligation to support children. Decisions about care and contact are based on what is in the best interests of the child. A domestic partner may also receive pension benefits as a factual dependent if they qualify as such under the definition of dependent in the regulations or conditions of that fund. A domestic partner will, however, not be entitled to their partner's pension interest on termination of their relationship. Marriage in terms of African customary law and divorce. South African customary law refers to that usually uncodified legal system developed and practiced by the indigenous communities of South Africa. Customary law has been defined as an established system of immemorial rules evolved from the way of life and natural wants of the people, the general context of which was a matter of common knowledge, coupled with precedents applying to special cases, which were retained in the memories of the chief and his counselors, their sons and their sons' sons until forgotten, or until they became part of the immemorial rules. The Recognition of Customary Marriages Act No. 120 of 1998 is a South African statute in terms of which marriages performed under African customary law, which are now recognized as legal marriages. It also reformed the law relating to the legal status of women in customary marriages, the financial consequences of customary marriage, and the dissolution of customary marriages, replacing customary law with statutory provisions. All customary marriages which were valid under customary law when the Act came into force, whether monogamous or polygamous, are recognized as marriages for all legal purposes. The spouses are obliged to register the marriage with the Department of Home Affairs within 3 months existed marriage before the Act came into force. There was a 1-year period for registration. However, a customary marriage is valid even if it is not registered, and there is no penalty for failure to register. The Act declares that a wife in a customary marriage has equal legal status and ability as her husband, including the ability to buy, own and sell the property and the ability to enter into contracts. All customary marriages contracted after the Act came into force are the same as a marriage in a community of property, meaning that all assets and liabilities belong to both spouses equally unless an ANC, antenuptial contract is drawn up. The Act applies the civil divorce law, the Divorce Act, 1979, to customary marriages, meaning that a customary marriage can only be dissolved by the High Court or a regional civil magistrate's court and only on the grounds of irretrievable breakdown of the marriage. The power of traditional leaders and other customary institutions to grant divorces is ended, but they may still mediate in spousal disputes before the legal divorce. The parties can decide the terms of the divorce and then the judge will issue the relevant orders regarding care and maintenance. If the court has to decide on these matters, it will take into account any arrangements that may have been made in terms of customary law. The wife's family may have to return all or part of the lobola, wedding gifts, to the husband's family unless the husband publicly rejected his wife for no reason at all. The parties can decide the terms of the divorce and then the judge will issue the relevant orders regarding care and maintenance. If the court has to decide on these matters, it will take into account any arrangements that may have been made in terms of customary law. The wife's family may have to return all or part of the lobola, wedding gifts, to the husband's family unless the husband publicly rejected his wife for no reason at all. Marriage and divorce. Marriage. Marriage, also called matrimony or wedlock, is a socially or ritually recognized union or legal contract between spouses that establishes rights and obligations between them. The definition of marriage is an institution in which interpersonal relationships, usually intimate and sexual, are acknowledged. Individuals may marry for several reasons, with legal, social, emotional, financial, spiritual, and religious consequences. Marriages are normally performed in a civil or religious ceremony known as a wedding ceremony. The act of marriage usually creates legal rights and obligations between the parties involved, and any offspring they may produce include interracial marriage, interfaith marriage, and same-sex marriage. A marriage in a community of property is achieved where there is no antenuptial contract, ANC. To achieve a marriage out of community of property, an antenuptial contract, ANC, must be drawn by a notary attorney and requires registration at the deeds office in the province where parties stay before the marriage ceremony. After the marriage, couple's marital status change into either three categories, and it is important that both parties consult with the attorney notary public beforehand and request an explanation of the various marital regimes and understands the implications of each on divorce or death. 1. In community of property. 2. Out of community with the exclusion of the accrual system in terms of the Matrimonial Property Act, 1984. 3. Out of community with the accrual system in terms of the Matrimonial Property Act, 1984. In community of property, no antenuptial contract is needed. There is one joint estate whereby the spouse is entitled to 1/2 undivided shares. Both parties are responsible for the debt incurred, binding the other spouse automatically. Section 14 of the Matrimonial Property Act 88 of 1984. Both spouses must sign with the purchasing of goods. The income of both spouses is seen as one pool of estate income. Debt must be paid out of the joint estate. In the case of administration or sequestration, it's one estate. The marriages of black persons according to traditional marriages are recognized as in community of property, with the implementation of Act 120 of 1998. Out of community with the exclusion of the accrual system, an antenuptial contract is needed. A public notary attorney draws up the contract and the contract is registered in the deeds office. There shall be no community of property between parties. There shall be no community of profit or loss between parties, and the accrual system provided for in terms of Chapter L of the Matrimonial Property Act, 1984, Act No. 88 of L. 984, is expressly excluded. Even though the spouse's matrimonial bond is bonded by a marriage certificate, each spouse keeps their estate. Thus, the one spouse's debt is not the other spouse's responsibility except if the spouse signed surety for the other spouse. Out of community with the accrual system, an antenuptial contract is needed. A public notary attorney draws up the contract and the contract is registered in the deeds office. There shall be no community of property between parties. There shall be no community of profit or loss between parties, and the marriage will be subject to the accrual system provided for in terms of Chapter 1 of the Matrimonial Property Act, 1984, Act No. 88 of 1984, will be inclusive. The netto value of the respective estates must be stated in the contract. The principle is the same as in community. In the case of a divorce or death, then the spouse is entitled to 1/2 of the other party whose estate is the largest or strongest. Each party handles his or her debt, except where the spouse has signed security for the spouse. If the ANC is not signed or registered timiously, the couple can approach the High Court using a joint condonation application for the late signing and / registration of the antenuptial contract, but the application must be made within a reasonable time. Instructions must be given to an attorney to bring such an application. Divorce. Marital status can be dissolved through a divorce that legally ends the marriage. The Divorce Act 70 of 1979 lays down the basis on which a court may dissolve the marriage. The divorce process will depend on the type marriage regime the spouses was married. Crucial issues that need attention during a divorce, namely, primary care of the children, contact and access to the children, maintenance for spouse and children, and division of the property. Remember, a divorce also have emotional implications on the family that needs attention, especially on children. Primary care and maintenance of the children. The family advocate always gets involved at the court and give a recommendation to the presiding judge or magistrate which parent is in the best position to look after the children and will stand for the children in the court if necessary. The recommendation includes who is the primary caregiver or guardian, or both parents may be jointly caregivers. The court, who is the upper guardian of all children, will issue a divorce order, but must decide to the best interest of the child and can be decided who will look after the children. This will depend on matter to matter. The parents can make an agreement about access to the children, or the court can decide. If it is not in the best interests of the children, then the court can restrict contact or allow contact under supervision. Both parents stay the children's natural guardians. The duty to maintain and support the children rests on the shoulders of both parents. The party who is in a better financial position will pay alimony to the other parent who has care of the child. Maintenance will be payable to the other parent until the child becomes of age, normally at the age of 18, or if the child attends tertiary education, this alimony can continue until completion of the child's studies. The court might also issue an order requiring the other party spousal maintenance. Because Hindu or Muslim marriages are not fully recognized as legal marriages, the wife has no legal status to claim support for herself after divorce, but the duty of support for the children by both parents remains. If there are problems with maintenance after the divorce has gone through, these can be taken to the maintenance officer at the magistrate's court. Whether one party will have to pay maintenance or support to the other party depends on the circumstances. If the parties cannot agree on how much should be paid, then the court will decide. Division of property. In community of property, the income of both spouses is seen as one estate. Property is the property of the joint estate. The default legal position is that civil marriages are in a community of property with accrual. This means that everything that you own is shared, including property and debts. Accrual means that everything that you earn or buy after you have married also becomes part of the joint estate. If you get divorced, the shared property is divided equally between the two. Out of community with the exclusion of the accrual system. Even though the spouse's matrimonial bond is bonded by a marriage certificate, Each spouse retains their own estate, meaning each person keeps their own property from before the marriage and keeps whatever they earn or acquires during the marriage. Thus the one spouse's debt is not the other spouse's responsibility except if the spouse signed surety for the other spouse. Out of community with the accrual system. There shall be no community of property between parties, and there shall be no community of profit or loss between parties, meaning each person keeps their own property from before the marriage, but anything that is accumulated during the marriage is shared. Some things, like inheritances or gifts, stay separate. Each party handles his or her own debt, except where the spouse has signed security for the spouse. Grounds for divorce in South Africa. A marriage may be dissolved by a court on mainly two grounds, namely the irretrievable breakdown of the marriage, the mental illness, or the continuous unconsciousness of a party to the marriage. The divorce process in South Africa. The divorce process in South Africa is relatively straightforward, and most divorces are normally lodged in the High Court. Until recently, the Regional Courts Amendment Act came into effect in 2010 to amend the Magistrates' Courts Act of 1944. To allow regional divisions of the magistrates' courts to also deal with divorce cases. A divorce action is instituted by the issuing of a summons and needs to be served personally on the defendant by the sheriff of the court. To determine jurisdiction in a divorce action, one or both parties must domiciled in the jurisdiction of the court on the date on which the action is instituted, or b. ordinarily resident in the jurisdiction of the court on the said date and has been ordinarily resident in South Africa for not less than 1 year at once before that date. Usually, there are two types of divorces: contested or uncontested divorces. An uncontested divorce can be completed in as little as 8 weeks. If a divorce is contested, it may take between 2 to 3 years, but it depends on the attorneys and parties. Divorces can be done on your own, in essence, a DIY, do-it-yourself divorce, but there are advantages and disadvantages. The forms to start the process are available at the clerk of the regional court in the district where you reside. See the process for do-it-yourself divorces. Visit our website hyperlink http://www.lawclinics.com www.lawclinics.com for more information. We hope you find our legal teachings to be valuable. Please visit our social media channels, like and subscribe for more teaching topics. Remember, knowledge is your power and peace of mind. Refer friends and family to share this knowledge. Regards, lawclinics.com.